Welcome to week 13. It's bill presentation week, and I will present a bill myself, if I can share my screen properly. There we go. Okay, from the beginning. Public law and legislative drafting, week 13. An act allowing corporate representation in eviction proceedings. I asked you to do three things in your bill presentations. State the problem, describe your bill, and tell us what measures of success you imagine. So let me start with the problem. In summary process cases in Massachusetts, that means residential eviction cases, landlord-tenant disputes in which the landlord is trying to regain possession, most landlords have lawyers. Most tenants do not. Here's some evidence. This is some public data that are available online. There's the URL at the bottom, and it's relatively recent. Of the 7,485 newly filed cases, 34.5% of them have plaintiffs, that means the person doing the suing, in this case the landlords or the housing provider. 34.5% of them are pro se, meaning they represent themselves. Pro se means for oneself. So the rest have attorneys. Now let's look at the right side of the screen. Percentage of pro se defendants, meaning tenants in this situation, 97.5% are pro se, meaning not represented by counsel. So more than 70% of landlords have lawyers, or about 70% of landlords have lawyers, and nearly all tenants do not. Is this a problem? And if so, what is the reason for the problem? If you think of the scales of justice, two sides in the scale, or two scales in the apparatus, and we don't like to think of them being out of kilter from the get-go. And there's a perception that if one side has a lawyer and the other doesn't, that just doesn't look fair. And looks really matter. The perception does matter, because for our legal system to continue and to have widespread popular support, or at least acquiescence, so as to avoid people taking the law into their own hands, we as a society need to have some faith that the system is fair. So it's a problem. And there are several proposed solutions. But before looking at solutions, let's think about why. Why do most landlords have lawyers? Why do most tenants not? Let's start with why do most landlords have attorneys? Well, because many of them are corporations. That's the first part of the answer. Many landlords incorporate. They take the form of an Inc. Let's say I was a landlord, I would become Peter Vickery Inc., Peter Vickery Incorporated. Why? Because of two things: limited liability, meaning if the corporation has debt, the creditor cannot reach through the corporation to get my money and house and car and so forth, except in a very narrow range of circumstances when a creditor can pierce the corporate veil, as the saying goes, reach through the corporation and grab the property of the individual, the real person behind the corporation. So limited liability means that there's this wall between the corporation and the individual's assets. And then there are some real tax advantages for housing providers who choose the corporate form. So there are definite advantages. One disadvantage is that corporations must have lawyers. When corporations go into court, they don't have any choice. They have to be represented by counsel. Although that's not what the statute says. There is an applicable statute, and I'll tell you what it is in a moment. And the statute does not say that at all. The statute does not say that corporations must be represented by counsel. Here's what it says. Massachusetts General Laws, Chapter 221, Section 48. No corporation or association shall practice or appear as an attorney for any person other than itself in any court in the Commonwealth or any judicial body, or hold itself out to the public, or advertise as being entitled to practice law. And no corporation or association shall draw agreements or other legal documents not relating to its lawful business, or draw wills, or give legal advice in matters not relating to its lawful business, or practice law, or hold itself out in any manner as being entitled to do any of the foregoing acts by or through any person, orally or by advertisement, letter or circular, provided that nothing herein shall prohibit a corporation or association from employing an attorney in regard to its own affairs or in any litigation to which it is or may be a party or the insurer of a party. So look at this in the highlighted language, other than itself, suggests that a corporation should be able to represent itself. Here's another relevant section, Chapter 221, Section 48. Parties may manage, prosecute, or defend their own suits personally, or by such attorneys as they may engage, but not more than 2 persons for each party shall, without permission of the court, be allowed to manage any case therein. So persons may manage, prosecute, or defend their own suits personally, which would seem to suggest that corporations could represent themselves. But here's a case from the Supreme Judicial Court from way back, 1988. We recognize that General Laws Chapter 221, Section 48, provides that parties may manage, prosecute, or defend their own suits personally or by such attorneys as they may engage. The word parties and words of similar import in similar statutes in other jurisdictions have consistently been construed to apply only to natural persons, not corporations, so as not to conflict with the well-established common law principle that, highlighted language, corporations must appear and be represented in court, if at all, by attorneys. There is no injustice in allowing natural persons, that's non-corporate persons, to appear pro se, meaning for themselves, while requiring persons who accept the advantages of incorporation to bear the burden of hiring counsel to sue or defend in court. What sort of burden? Thousands of dollars in legal fees. That's a burden. So when you go to housing court and you're a landlord and you've chosen the corporate form, you have to hire an attorney. Why? Because Chapter 221, Section 48 or 46 says so? No, the statute does not say that at all. But because Varney Enterprises, Inc. versus WMF, Inc., 1988 Supreme Judicial Court case says so. And more recently, in 2018, the Supreme Judicial Court said this about a property manager who had filed summary process on behalf of an owner. Where the plaintiff in a summary process action is neither the owner nor the lessor of the property, the court must dismiss the complaint with prejudice for lack of subject matter jurisdiction, regardless of whether a motion to dismiss has been presented by the defendant. So if somebody files summary process, files an eviction case for another person, and the person doing the filing is not an attorney, the court will dismiss the case. So if you're a corporation, a corporate landlord, and your property manager, or let's say the president of the corporation, files a summary process case in court, the court will dismiss it. Because the statute says so? No. Because the court says so. So corporations must have lawyers because the courts say so. If we want to level the playing field, one way to do that is to do away with this requirement that all corporate landlords must have lawyers. They would prefer not to because hiring a lawyer costs money, and this is a business. Therefore, here is my proposal, an act allowing corporate officers to represent the corporation in eviction proceedings, an act allowing, not an act to allow. You will recall from the legislative drafting manual that that's how we style titles in Massachusetts. Section 1, all caps for Section 1 of your bill, remember? Section 46 of Chapter 221 of the General Laws, as appearing in the 2018 official edition, is hereby amended by inserting at the end of the first sentence, after the words "of a party," the following: or prohibit the president, treasurer, or secretary of a corporation from representing the corporation in summary process proceedings. What would that do? Here's what the amended version of the statute would look like. Provided that nothing herein shall prohibit a corporation or association from employing an attorney in regard to its own affairs or in any litigation to which it is or may be a party or the insurer of a party, or prohibit the president, treasurer, or secretary of a corporation from representing the corporation in summary process proceedings. So the point of this is to undo that decision in Varney, undo that decision in Hatcher, and say that nothing in the statute shall be construed as prohibiting the president, treasurer, or secretary of a corporation, those are the usual officers, from representing the corporation in summary process proceedings, meaning in eviction proceedings. How would one measure success? If this bill were to become law, how would we know whether it had worked? Well, I remind you of this set of statistics that I showed you earlier. The percentage of pro se plaintiffs, meaning pro se landlords representing themselves, is currently 34.5%. Number of pro se defendants, 97.5%. Success would look like this. The number of pro se plaintiffs, meaning landlords not represented by counsel, would go up so that it's the same as pro se defendants. You know, it wouldn't have to be exactly the same, but if it were exactly the same, I think that would be success. We would know that the bill had worked.